question, therefore, is whether or not the warrant of arrest issued by the ICC after our withdrawal is something we have to cooperate with under 127 paragraph 2. In my view, yes. And therefore, in my view, the warrant of arrest is legal. However, I believe that the surrender is not, because the surrender must be pursuant to a treaty, and therefore our own law, Section 17 of Republic Act 9851, brought back the Statute of Rome, even after withdrawal, because it requires that a surrender must be pursuant to the applicable treaty. And therefore, in this case, the applicable treaty remains the Statute of Rome. And thus, we have to follow Article 59 of the Statute of Rome, which requires that the custodial state, namely the Philippines, must first bring the arrested person to a local court to determine two things: whether or not the person is really the one named in the warrant; second, whether or not the person has been informed of the charges against him or her. This was not done. Therefore, there was, in my view, a violation in the act of surrender. However, Madam Chair, this is in the forum of the Philippines, but in the forum of the ICC, different rules apply. In the ICC, I believe they follow what is called mali coptus bene detentus, meaning that even if the arrest is illegal, the detention can be legal. It does not automatically mean that if the arrest was illegal, the person arrested must be released. Therefore, it depends on whether you're talking about Philippine Forum or the ICC. The ICC, I believe, will follow their own procedure. Whereas in the Philippines, as it is now pending in the Philippine Supreme Court, in my view, there is a violation and there will be consequences for that violation.